Welcome to this explainer. Today, we're diving straight into a massive, literal game changer in India's criminal justice system. We're talking about the historic transition from those dusty, centuries-old colonial laws to the brand new Bhartiya Nyaya Sanhita, or BNS, of 2023. Honestly, this is arguably the single most significant legal overhaul we've seen in recent history.
Okay, let's take a quick look at our docket for the day. We'll start with the evolution of Indian law, then look at the structure of the BNS, unpack legal jurisdiction, decode the actual language of the law, and finally, get into the core principles of criminal liability. Sound good? Let's get into it. All right, Part 1, the evolution of Indian law. We're going from ancient texts all the way to modern codes.
So if we trace this all the way back, criminal justice in India started in the ancient era. Think Dharma and texts like the Manusmriti. Fast forward, and the medieval period brings in Islamic criminal law. Then, boom, 1860 hits. The British introduced the Indian Penal Code to unify everything across the territories. Post-1947, independent courts start viewing this old code through a much-needed lens of human rights and due process. Which brings us to 2023. The BNS completely modernizes the system, finally stripping away that colonial legacy.
Now you've got to understand, this push for modernization wasn't just some random decision. It was heavily influenced by our courts constantly pushing the envelope on fair trial principles over the decades. I mean, look at landmark cases like Kedarnath Singh on sedition, or Maneka Gandhi on personal liberty. They proved that a society with a modern constitution just couldn't survive on an 1860 framework forever. We absolutely needed a system built for today's social and technological realities. Moving on to Section 2. Let's look at the structure of the BNS, the actual blueprint of justice. So, the BNS is broken down into these highly structured chapters to make sure justice is administered with absolute clarity. It kicks off with preliminary provisions and general explanations, basically defining the ground rules that apply to the whole code. Then we hit general exceptions. This part is crucial because it tells us when a crime isn't actually a crime. Think self-defense, a genuine mistake of fact, or insanity. Next up is punishments, which, interestingly, now includes community service right alongside your standard fines and jail time. And finally, it lists the specific offenses, covering everything from bodily harm to modern threats like cybercrime and terrorism. Now, how does the law decide police powers? It categorizes offenses by severity. If a crime is cognizable, it's serious enough that the police can literally just arrest a suspect on the spot. No magistrate's warrant needed. But if it's non-cognizable, well, they generally have to go get that warrant first. It's a delicate balancing act, right? Swift law enforcement on one side, protecting individual liberty on the other. And once someone is actually arrested, the procedural paths diverge completely based on how heavy the crime is. For a bailable offense, the accused can just claim bail as a matter of right. But if it's a non-bailable offense, yeah, that right vanishes. Suddenly, getting out is entirely up to the judge's discretion. Finally, how do these cases actually resolve? This is where we get the compoundable versus non-compoundable split. Basically, can the two parties just settle the matter privately? If yes, it's compoundable. But if the crime is so severe that it's considered an offense against society as a whole, it's non-compoundable. Settlement is off the table, and a full trial is absolutely mandatory. This whole classification system is what tells investigators and courts exactly how to handle a suspect from day one.
All right, that brings us to Section 3, legal jurisdiction. Exactly how far does this law reach? You know, you'd probably assume a nation's laws just stop right at its physical borders. I mean, borders are borders, right? But is that actually the case for the BNS?
Well, let's dive into a pretty surprising reality here. Under Section 1, the BNS doesn't just stop at India's land, water, or airspace. Thanks to something called extraterritorial jurisdiction, Indian criminal law actually follows its citizens abroad. Plus, it covers any crime committed on an Indian-registered ship or aircraft, no matter where it is on the globe. And, in a huge update for the modern era, it aggressively protects the country from transnational threats. This means someone can absolutely be prosecuted in India for cybercrimes or terrorism targeting the nation, even if they've literally never set foot on Indian soil.
And there is rock-solid legal precedent backing up this long arm of the law. Just look at the classic case of Mubarak Ali Ahmed versus the state of Bombay, where the court formally backed this extraterritorial power. Honestly, in today's hyper-connected digital world, protecting sovereignty from cross-border crime is more crucial than ever.
Okay, Section 4, the language of law. We're getting into the definitions and general explanations.
So uniform interpretation is pretty much the backbone of the entire justice system. If a judge in one state defines a word differently than a judge in another, the whole thing falls apart. That's exactly why Section 2 of the BNS strictly defines its legal terms. It spells out that criminal liability can come from an act, like actively doing something illegal, or an omission, which is failing to do something when you have a legal duty to step up. Crucially, it brings terms into the 21st century by including digital evidence, like electronic records. Section 3 goes further to standardize things, noting that, legally speaking, the masculine gender generally includes the feminine, and the singular includes the plural, unless the context says otherwise.
Now here's a fun fact. In the legal realm, a person isn't always a living, breathing human being. Under the BNS, the word person is defined broadly enough to formally include companies, associations, and corporate entities, right alongside human individuals. No ambiguity there. To see this in action, check out the State of Maharashtra versus Syndicate Transport Co. Ltd. In this case, the court really hammered home the concept of corporate criminal liability. Because a company is legally recognized as a person, it can 100% be held criminally liable for its actions. So no, corporations cannot just hide behind their logos to escape justice.
And finally, Section 5, Principles of Criminal Liability. Let's step inside the mind of a crime.
So, to actually establish a crime, there are generally 5 sequential elements that all need to exist together. This is what keeps the system fair and prevents arbitrary prosecutions. First, you need a legally capable human being or entity. Second, there has to be a guilty act. Third, and this is key, there must be a guilty mind behind that act. Fourth, this whole situation has to result in some kind of injury or harm, physical, mental, financial, whatever. And fifth, there has to be a legally prescribed punishment for that specific conduct. Basically, you can't be punished unless the law expressly says what you did was an offense.
Let's unpack these, starting with actus reus. That's Latin for guilty act. It means there needs to be a tangible physical action, a prohibited conduct, or a failure to act when you're legally supposed to. You can't be thrown in jail just for having a dark thought. There has to be a real-world act.
But here's the catch. An act all by itself usually doesn't make you a criminal. It generally needs to be paired with mens rea, or the guilty mind. We're talking about the intention, the knowledge, the recklessness, or the negligence driving the act. Think about it. If you accidentally bump into someone and their phone drops and shatters, sure, the physical act is there, but the mens rea, the actual intent to smash their phone, is totally missing, and that completely changes your legal liability.
There's a landmark case that really drives this home. Nathulal versus the state of Madhya Pradesh. The court was incredibly clear here, emphasizing that if we want to protect individual liberty, we absolutely must prove the accused actually possessed a guilty mind. The prosecution has to establish that mental element to get a standard conviction.
However, there is a really fascinating exception to this rule. While standard liability means proving both the guilty act and the guilty mind, there's a concept called strict liability. For certain public welfare and regulatory offenses, you don't even need to prove a guilty mind. The act itself is enough. A perfect example from our sources is the state of Maharashtra versus Mayor Hans George. The court showed that strict liability applies to specific offenses to protect the broader welfare of society regardless of what the individual actually intended.
As we wrap up this explainer on the complex anatomy of Indian justice, it's pretty clear the BNS has torn down a colonial framework to build something thoroughly modern, cyber-conscious, and focused on the victim. It redefines borders, it redefines what a person is, and it sharpens the exact elements needed to prove a crime. So, I'll leave you with this to ponder. If this new code has the power to redefine everything from digital evidence to who can be held strictly liable, how profoundly is the Bhartiya Nyaya Sanhita going to reshape the everyday fabric of Indian society and commerce in the decades to come? Thanks for tuning in, and keep asking the big questions.